All right, well, good morning, everybody. Thank you for joining us today. Today, what we're going to do is kind of focus on the basics of estate planning. Right now, what I'm doing is giving you an example of what we do in the office of Dale Bethel, Bethel Law Corporation. We have offices both in Victorville, Redlands, and in Temecula. And our planning disciplines are really, as an example that I'm giving you here, is up on that chart. Today, we're not going to talk about everything that's up there. What we're going to do is focus on the little legal section of the pie and go into basic estate planning. So with that in mind, let's start with a simple question. It's not working. Sorry. All right. So, what is estate planning? I always like to start with this question just to break it down into simple formation, because the example of what estate planning is also mimics what a living trust actually does. And so I've broken it down really into three basic elements. And the first element of estate planning is creation of one's estate. This is something that we're all doing, because we're here and we're accumulating assets. And it's very normal that once we have assets accumulated, we're going to worry about managing them, preserving them, and then what do you want to do with them? So my point of bringing up the elements of estate planning is simply to mention that in the future, when we talk about the trust, you'll notice that the trust follows these elements. So in other words, having a trust is nothing more than what you're already doing anyway. Now, one of the key elements that we're going to talk about today is how to keep our affairs private versus how to have our affairs public. And what I mean by public is we have to go to court. And the whole idea is not to go to court. And one of the biggest problems with doing nothing when it comes to estate planning is it does drag us into court. And one of the biggest areas that we have a problem with are fees. And so what we want to do is eliminate those fees, because we simply do so by eliminating going to court. Another area of estate planning that we're not going to get into today, but I just want to mention quickly, is estate planning does deal with taxes and the payment, especially of estate or death taxes. This is called advanced estate planning, and I always like to show this chart here just to give you a quick idea of what I'm getting at. It's really for the very, very wealthy. And we do very wealthy estates when it comes to estate planning. I like to show this chart because it gives you an example of who did something right and who did something wrong. Elvis is always a great example of what not to do when it comes to an estate plan. Here's a gentleman that ended up having nothing in writing upon his untimely death, and as a result of having nothing in writing, he immediately, or his family, his estate, lost $7 million as a result. Now, both Rockefeller and Disney, they did have certain estate planning documents, trust involved with their estate. And as you can see, they were able to keep, money within their family structure, but not as much as they could or should have. And the one we always like to brag about is Kaiser. Here's one with $56 million estate. And as a result of his good planning, the $55 million were actually kept within his family structure. So the moral of the story here is, if you do have a lot of money and you have a large estate, large assets, do give us a call, and I'll be happy to go over estate planning with you when it comes to advanced estate planning. However, today, we're not going to talk about what the wealthy do. We're going to talk about what everybody has to do when it comes to setting up one's own private estate. And in California, we really have three choices. You can do nothing when we call that intestate succession. If you do nothing to plan your estate, believe it or not, the state of California does have it all figured out for you. They have their law books, and those law books are going to dictate, who your heirs are and how much everybody's going to get. But if you think about it, if you're going to allow the state of California to dictate who your heirs are and how much everybody's going to get, you don't have a say-so. So in order to gain your own say-so, your own private distribution plan, you have to have a writing. And the first level of having a writing is a will. And at least with the will, what you now have is a written instruction to the court outlining who your heirs are and how much everybody's going to get. But the operative word here is court. So you'll notice that if you do nothing to plan your estate, or if you choose just to do a will, you're in the public arena. In other words, we have to go to court, and all the fees that I initially mentioned all kick in as a result of that. Now, the opposite of going to court and keeping your affairs private is the living trust. Living trusts are very popular on the West Coast, especially in California. Anybody that simply owns a home or has more than $166,250 will find themselves in a probate situation. So in order to avoid that, you use the living trust as your estate plan. Now, a lot of people ask me what probate's all about, and I always assume everybody kind of knows. However, what probate really is if I pass away, I am not here to sign title changes down to my family, which simply means how do you perfect a clean title down to the next generation? Well, you need to go to court and get a judge's order. That's what probate's all about. And of course, the exception is the living trust, and we'll get into why that is. But once you're in court, that's when all those fees kick in that we initially mentioned. And I always like to show this chart up here to give you a quick idea what those fees are. This chart is out of date a little bit in the sense that the $150,000 that kicks off the first attorney fee level is now up to $166,250. So the first $166,250 of any gross estate going through the probate process equates to a $4,000 attorney fee. Then at $266,250, you're going to have a $7,000 fee, and then my fee continues to climb $2,000 for every additional $100,000 of gross estate that you have going through the probate process. And you'll note that probate is all geared up on gross estate, not net. If you have a $500,000 home and a $250,000 mortgage on it, it does not matter in terms of my fees. I get paid on the full $500,000 value of that house. And then you may be thinking that these fees are a lot, and they are. However, they're only half. In fact, they're not even really half when it gets down to it. What I'm getting at is this, that every executor who handles your estate also is entitled to the same fee that the attorney gets. So everything on the right column there under attorney fees doubles. Half goes to, or I should say one amount goes to the attorney, one amount goes to the executor, and then you know you can't go into court for free, right? You always have to pony up a filing fee, a notice of publication of death fee, usually a probate referee fee, and good old California has figured out how to charge you to close the estate. So there's a closing fee now when it comes to probate. All these fees typically add up to around $2,200, and then you have the attorney fees, and then you have the executor fees. So the moral of this story is simply to stay out of court. If you stay out of court, you naturally avoid all these fees. But the quickest and easiest way to get into these court problems and these fee structures is, once again, to do nothing. And we call that intestate succession. Again, intestate succession is an estate plan by default, in the sense you're defaulting to the state of California to figure out who your heirs are and how much everybody's going to get. So that's what I mean by the bullet point up here, calling the fact that it does require probate. We do have to present ourselves in front of a judge in order to pass that clean title. And then what I mean by no guarantee is you don't have a writing, so the judge has total discretion to figure out who your heirs are and how much everybody's going to get. So if in fact you want to say so, the first step is having a writing, and that first level of a writing would be a will. However, as we mentioned before, a will is nothing but an estate plan outlining who your heirs are and how much everybody's going to get for the court. So the bottom line with the will is we have to go to court. We have to have a judge basically pass orders in order to pass a clean title down to the next generation. Now, the advantages of a will is it does cost a little bit less to get started than, say, getting a full trust package, because naturally you only get a will when it comes to getting a will. When it comes to getting a trust, there are a package of other documents that makes everything work, which we'll go over here in a moment. But a will is also simple during lifetime. There's nothing to think about. Usually when we do a will, we get it done, we put it into, the file cabinet at home, and we forget that it's there. And the next thing you know, 20, 30 years later, and I'm not exaggerating, we think that about it again, and we pull it out and notice that it's all completely out of date. The reason I mention this is because a lot of times I am going into court on probates simply with a very old will. And a lot of times that will not reflect the current family dynamics. You know, you might have more children that you've accumulated, or you have less children that you've accumulated, or you might have even changed spouses along the way. Now, that may sound funny, but one of the biggest fights I always get into in court is when a will pops up that has an ex-spouse as, you know, your beneficiary, and then yet you have a new spouse now and maybe even a new family, and they're all arguing with the old family as to who's supposed to get what. So I guess the moral of that story is if you are going to change spouses, do not forget to change your estate plan. With that, number 3, guaranteed results. What I mean by that is you do have a writing and the judge has the ability to follow that writing. But again, a judge also has discretion to change the writing once we're in court in order to match the family dynamics if that will does not adequately reflect who your family really is. So the disadvantages of the will is everything I've kind of been emphasizing up to this point. It does require probate. That means we have to go to court and spend the money that I showed you on that chart. And the other big problem is it takes forever. Right now, a normal probate will take about a year to get through the system. Now, if there's any arguments or any challenges to anything, it drags out to 2 or 3 years in order to get through, you know, the probate process. Now, it all depends on the courts that we're filing at. Downtown Los Angeles has consolidated all of the outlining Los Angeles County courts into downtown LA for probate, which means they have a very large docket and they are very busy, and it takes forever to get through the Los Angeles court system on a probate. About 2.5 years seems to be my average at this point in time. San Bernardino is a complete mess right now in terms of how probate is being run. They seem to be having problems with filing documents, say, on the second floor and it not being scanned. That's the word they're using, scanned into the court file on the 10th floor. So by the time I get around to appearing, there appears to be a lack of documentation in the judge's file, which invariably means that the judge more than likely is going to continue it. And continuance caused more delays, and so we're having issues with San Bernardino at the moment. However, Riverside County is running very smoothly. They do have their act together. San Diego does, and so those courts are actually working fairly well at this point in time. Again, I emphasize this because a lot of times preparing and filing paperwork in court doesn't necessarily guarantee a smooth transition. There's a lot of other factors involved when it comes to going into court, and that includes how the court is actually being run internally. So with that, the disadvantages of a will does require the probate. We have to go to court and spend the money to be there, and we have those substantial time delays that do have a way of cropping up, and depending on which court we're acting in, take longer than another. So with that, I've kind of gone through the general rule of what the opening presentation is all about. And that is, if you decide, you know, to use a will or do nothing, we're going to end up in court, and it is going to take, you know, anywhere from a year to 2.5 years to get through the system before anything actually gets resolved. Now, there are exceptions to this general rule, one of them being joint tenant titling, and then small estates, and then the living trust itself, of course, is an exception. Now, joint tenancy is a way of holding title. It is not an estate plan, and a lot of people try to use joint tenancy as an estate plan. I highly recommend you don't really do that because, well, bottom line is joint tenancy is something that we do when we first get married and we first start buying properties together. We like joint tenancy because it has a right of survivorship. So that means upon the death of one, it automatically goes to the other, and you don't need a will or a trust or anything in that regard. However, there is a benefit for husband and wives having a living trust, and then it has to do with a tax consequence when it comes to a stepped-up tax basis. In joint tenancy, only the decedent's half interest steps up upon their death, you know, to raise the basis in your property, which gets rid of capital gains taxes. The survivor's half does not step up. So if you're a surviving spouse in joint tenancy, you can sell the property at that point in time because, well, you own it. However, you'll have a capital gain hit. If you use a living trust between husband and wife on first death between spouses, both halves step up, which means the surviving spouse now can downsize and consolidate, get rid of those rental properties maybe at that point in time without paying a capital gains tax because both halves step up upon the death of one. And then on second death, one of the beauties of having a living trust too is there is another step up that occurs on the basis of the property, which means your children can turn around and sell that property without a capital gain hit. Now, joint tenancy, when it's not used properly, in other words, you try to use it as an estate plan, that's usually when things cause a problem. You know, joint tenancy may be okay between husband and wife, except for what I just talked about. But what happens when you're a single surviving spouse? You're going to have a probate. You can't have joint tenancy unless you start putting sons and daughters on properties as a joint owner with you. And you don't want to do that. You actually do a disservice to your children by putting their names on your deed to your house, for example, because, once again, when you pass away, the other half does not, and there's not a stepped up tax basis that occurs, and you're bootstrapping your children into a capital gains tax hit. If you have any questions on that, please give us a call or come in for a free consultation, and we'll be happy to go over that with you with maybe a better explanation. But the other exception to probate is small estates. Now, there's two triggers for probate in California. Once again, it's real estate. A piece of land always is going to trigger a probate, or more than $166,250 of personal property. Now, real estate does have different levels of probate that we can get involved in based on the value of the estate. You know, if it's under $55,000, we can usually get away with an affidavit of death and not have a full-blown probate. If it's between, I should say the real estate is valued between $55,000 and $166,250, we can do a small type probate. If it's over $166,000 in value, then we do have to go into a full-blown probate on that. So when you come in and talk to me about a probate for your family, we always value the properties and see which category of probate you fit into. If you do have a small value on a piece of land, maybe we can do something less than a full-blown probate. So that brings me to the living trust itself. And before I get into that, I always like to show this slide here just to kind of give you an idea that I do have a lot of clients in my office that will set up their living trust simply to avoid probate on the house, even though they do not have enough money in the bank to actually trigger the probate. So the first question I always ask folks when they come to see me is, do you have a house? And if they say yes, then I know they need that estate plan designed around a living trust. Real estate is really the trigger in California when it comes to using a trust versus not using a trust. Now, I show this slide here because this was a lady who just refused to do the living trust, didn't listen to her family who were trying to get her involved in it, and sure enough, at some point, she did pass away. And as a result, instead of having a clean end to her life in the sense of passing the family down with the house very easily, we had to go to probate. And as you can see, it took me more than a year to get through the probate process and a full cost of $9,000, which is way more expensive than if she would have just done the living trust in the first place. So I do want to emphasize that those of you who do just have real estate that's going to trigger the need for a trust, yes, you still need to get that trust set up in order to avoid probate on that real estate. So with that in mind, that does bring us to the living trust. You know, we call it a living trust because it is made during your lifetime. I always like to think of it as a living trust because it's alive in the sense that, remember, a will does not do us any good during our lifetime. It's just a written instruction to the court outlining our heirs and how much they're going to get. A living trust, however, protects us during our lifetime, especially when it comes to issues of disability and incapacity. So that's why I mean it's alive. It actually does something for us. We get something out of having our living trust ourselves. Excuse me. Now, the operative word for a living trust is that it's revocable. That means you have the right to always amend and change that living trust. It's designed within those documents. And I caution anybody out there that still has an old 1990s living trust, you just may have an AB type trust, and we want to look at that. That is a type of document that's designed to hedge against estate taxes, and it does have ramifications upon first death in being irrevocable versus revocable. So we want to make sure you're not involved in that anymore, as you really don't need it. So with that, a living revocable trust is what we'll be talking about. Once again, before I get into it, I want to give you the idea of the difference between a living trust and a testamentary trust. A living trust is made during your lifetime, whereas a testamentary trust is designed to be implemented upon your death. Now, I do not do a lot of testamentary trust, but there's one testamentary trust we use a lot, and that has to do with a special needs trust. I want to mention this at this particular point in time for those of you who may have a disabled child in your family. You as the parent have to take into consideration when you design your estate plan the special needs of your child. That child may be on public benefit, and you cannot enrich them with an inheritance, because if you do so, it's going to ruin or blow their public benefit or their ability to actually get it. So the design I'm showing you up here on the slide presentation basically shows that most testamentary trusts are designed to go through court, needing a judge's sanction of okay, and we are really talking about today how to stay out of court. So when we do a special needs testamentary trust, instead of using a will to get it set up, we use your own revocable living trust to do so. That avoids the probate, but the point of what I'm getting at is simply this. If you have a special needs child, you do not send their share to them personally because it will ruin their public benefit. What you do is you send their share to the testamentary special needs trust. Now, they get to keep their public benefit because the special needs trust owns their inheritance. And yet at the same time, that special needs trust beneficiary is that special needs child. So in short, the special needs child keeps their public benefit and now has their special needs trust that they can draw on for extra funds and provide a better standard of living, basically, than what just public benefit will do. So for those of you out there who do have a special needs child in your family, come in and talk to us, and I'll be happy to go over the details of a special needs trust and how it basically works with your revocable living trust. So with that, let's get into the living trust itself. If you start with me, it's really a two-step process. We're not only going to create all the documents, we're going to make sure that it's actually working and the properties avoid the probate. So I will create the documents for you, but at the same time, we want to make sure that we have funded the proper property into the name of your trust. Funding is the term that we use when we talk about titling assets under the name of the trust. So in short, you're never going to use joint tenant titling as husband and wife. You're always going to title your new assets that you accumulate into both your names as trustees of your trust now that you have your trust, set up. So let's talk about the creation. I always like to use the analogy that the creation is getting the car, but we have to put the gas in the engine to make it go when it comes to property transfers. So what we're going to do now on the next slide is talk about the car and how we put it together. And I like this slide because by the time we get done with it, you'll know exactly why and how a trust actually works. So remember that first slide we started off with where it went into the elements of estate planning, where you create your estate, you preserve and manage it, and now what do you want to do with it? Well, that's exactly how a trust is laid out. So in this sense, you are the maker of your estate, you accumulate assets, so you're going to be the maker of your trust, and we just happen to call you a trustor. You're also going to be the manager of your trust assets because you're already the manager of the assets that you have that we're going to title into the trust to avoid the probate. Now we just simply call you a trustee. So you're the trustor, maker of your trust, you're the trustee, the manager of your trust, and you're the first beneficiary of your own trust, meaning you can do anything you want with it. So a revocable living trust has you in total control where you can do anything you want just like normal. Now, the beauty of a living trust comes into play when something happens to you. Are you disabled, incompetent, or have you passed away? So a successor trustee is the person you're going to pick, usually out of your own family. Son, daughter is usually the choice that people mostly make, but it could be anybody. My point being is you're going to pick a successor trustee who can step in at death and wrap up the trust estate, just like an executor does under a will, except for one major difference. An executor under a will has to go to court and get the judge's approval to pass a clean title, whereas under a trust, the successor trustee has all the power in the language of the trust to pass a clean title themselves, meaning that they can sign title changes, which means they do not need a judge in the middle of it, which is why the trust is the way we keep our affairs private. Now, also what a successor trustee can do is step in when you're incompetent. This is something that an executor under a will never can do. And so what I'm getting at is this is why the document is alive. This document, the trust itself, will help you in the sense that if you become incompetent, you're legally arranging for your family to privately take care of you. And that's the beauty of the trust, in my opinion, is it's one thing to pass away and have the family receive your accumulated assets, without a lot of hassle. But it's another thing to make sure that you're legally in a position to have your family take care of you if you're disabled or incompetent. That is a big deal. So with that in mind, let's talk about putting the gas in the engine. So what I mean is funding the trust, and the logic behind what we want to do is make sure that your real estate all gets titled under the name of the trust. If you have business interests like corporations or limited liability companies, that falls into that category too. We want to make sure that they are titled under the name of the trust to avoid the probate. I am recommending that you do not put your timeshares under the name of the trust. Timeshare companies will hold the trust liable for ongoing fees and dues even after you pass away if you do title the timeshare under the name of the trust. So the easy solution here is not to title it under the trust. That means your family can tell the timeshare company that they did not sign the contract. They're not liable, nor is the trust liable. And the family can turn the timeshare back to the timeshare company. Yes, they don't get any money out of it, but at least they get out from underneath the contract and the ongoing fees and dues. Now, on the left-hand bottom corner, this is what I mean by stocks, bonds, mutual funds. They should all be titled under the name of the trust. Specifically, your after-tax brokerage investments should be titled under the name of the trust. Also, on the upper right-hand corner, your large savings and CDs. Now, what's a large savings? Well, remember, what triggers a probate is $166,250 of personal property. And so, therefore, you do not want to pass that threshold of having an account with more money than that outside of the name of the trust. Otherwise, you do have the probate. So for me, a small savings account is in the $20,000, $30,000, $40,000 range. It's not going to trigger a probate. You do not have to put it under the name of the trust because it simply isn't going to trigger a probate in the first place. Once you start getting around that $50,000, $60,000 range, and especially if you're growing your savings account, you definitely want that savings account under the name of the trust. So the same thing applies when it comes to CDs. A $20,000, $30,000 CD is not going to trigger a probate. However, I like putting CDs under the name of the trust no matter what their value is because it's a very easy asset to title under the trust. You simply tell the bank that you have a trust when you set up your CD time period, and they title it that way, and that's it. It's that simple, really, when it gets right down to it. Now, there's a lot of assets we haven't talked about, but specifically I want to mention what we do not put under the name of the trust. And that's going to be your normal checking account that runs your normal monthly bills and gets your direct deposits. We do not want that under the name of the trust because, number one, there's not enough money in it to ever trigger a probate. And number two, though, what you want to do, especially after you lose a spouse, you start thinking about this, you want to put your trusted son or daughter on that checking account with you. In an emergency, you want to have them in an ability to be able to pay the ongoing bills and expenses. And if your direct deposits are going in that checking account, there's always a cash flow every month where your family can write checks on your behalf and make sure those bills are paid for. So from a practical standpoint, do not put the checking account under the name of the trust. Just keep it in your name or both your names, and we're good to go. Other assets that we're not going to put under the name of the trust is your cars and all your personal stuff, okay? Now, I know we invest in IRAs, pension, retirement plans like 401ks. I know we have life insurances and annuities out there. All four of those products also do not go under the name of the trust. And the reason for that is when you set up your IRA, you have to pick a beneficiary. So that act of picking a beneficiary keeps it out of the probate world. So I will go over these assets that you may have when you come in and talk to me. Well, I have a little worksheet that says what goes in the trust, what stays out of the trust. We'll fill it out right then and there, and you'll go home knowing exactly how the trust is going to function and work for you. Now, in the future, you're going to add assets to your trust, and you're going to take assets out of the trust. You have the power to do that. So there is no restraint on moving monies, properties in and out of the trust as you see fit as the years go by. You go out and buy a new house. You're going to tell escrow when they ask you, how do you want the grant and deed? You're going to now say, put it under the name of my trust rather than saying joint tenancy. All right, with that in mind, I always like to show this slide here because we've talked a lot about changing the titles on your assets. And again, as husband and wife, you're never going to use joint tenant titling anymore because you're going to use the name of your trust. So as you can see, we're going to go from both of you as joint tenants to both of you as trustees of the Jones Family Trust. Works the same way for single people. And I just wanted to give you a visual when it comes down to what I mean by changing the title names, on your assets in order to conform with avoiding the probate. So the advantages of a living trust is you're going to stay out of court. We're going to avoid all that court appearance and all the time delays that go with it, and most importantly, all the expenses. If we're not in court, we're not going to have to pay for it, of course. So with that, the disadvantages of a living trust is maybe the cost. It costs a little bit more to get the trust package set up than, say, just a will, because you do not get just the trust. When you get your living trust set up, you're going to get a pour-over will, a healthcare power of attorney that we call advanced healthcare directives now. You're also going to get a financial power of attorney, a Schedule A, and if you're husband and wife, you're going to get a community property statement. Now, nuisance factor. The only thing I can think of is that now that you have a trust set up, there's only one thing you have to remember. That is when you accumulate new assets, you buy a new home, you open up a new CD, you open up a new brokerage account, you have to remember to say, title it under the name of the trust. Now, if you forget this, we're really set up here in the office to take your phone calls. If you have any questions, we'll be happy to answer them in terms of, titling new assets that you've accumulated into the trust. We'll even help you out in that regard. We work with flat fees. What that means is we don't charge hourly, which means you as a client of the office has an open door to the office. All you have to do is call or come in and ask for an appointment, and it's a free appointment and a free phone call. No one's going to send you a bill in the mail. That also goes to your family. If anything happens to you or the family needs to know questions on how to take care of long-term care and things of that nature that do crop up, we have an open door to your family in order to discuss those matters without paying a fee at that point in time. Once you ask us to do something, we'll figure out a flat fee and we'll go from there. Now, possible mismanagement, I don't think of that as a disadvantage in the sense that I'm sure you're picking people you trust in order to manage things if you can. Most folks do pick their family, their children, in a blended family where you got children from previous marriages. Sometimes a lot of my clients will pick one from each side to work together. That used to work very well in the old days, but lately we've been having problems where if you do pick one from each side of the family, they have a tendency not to get along. And next thing you know, they're like ignoring each other or refusing to work with each other, and that causes its own set of problems. So basically what I'm getting at is I'll go over all this with you when you come in and talk to me, and we'll figure out what would be the most efficient and best way from a inside political situation for the family on how to make sure everybody feels comfortable and cozy, that things are being handled properly. And I'll go over what your options are on picking, or I should say in picking, a successor trustee with you. We do want to avoid mismanagement problems, and that is a very big key that we focus on when it comes to advising you. So with that, what I've done is gone through the beginning of all this, and in the sense of showing you that if you use a will, it might be a little bit easier to get started, a little less expensive, but in the end, it's going to be much more difficult and much more expensive going through the court system. Whereas the living trust might be a little bit more expensive to get started, not much, but in the end, it's so much easier and you avoid all those court fees. So that's the basic summary of what we've been talking about. The will puts you in court, the living trust keeps you out of court. Now, what I do want to mention is, we have large estates that we work with, and I mentioned in the beginning that if anybody has an old trust dating back to the 1990s, it's a good possibility you were given an AB type trust, which is what I'm showing you up here on the screen. The A is always considered the survivor, the above ground person. The B is always considered the decedent, the below ground person. So a nice easy way of remembering what AB means, it boils down to above ground versus below ground. But this is a type of trust that was popular in the 1990s because the federal estate tax exemption only was good up to $600,000 of value. In California, you have a $500,000 home and money in the bank and a couple cars in the garage, you're over $600,000. So therefore, back in the day, this impacted a lot of people, and a lot of people were automatically given an AB trust. Over the years, that $600,000 exemption has changed. It's literally up to $11.7 million per person today. So that means in order to have a trust like that, you really need over, $24 million before this trust does you any good. So what I'm getting at is you don't need an AB trust. If you've got an old one that hasn't been updated since the 1990s, you definitely want to come in and get that modified and get out from underneath of it. An AB trust is a contract. It forces the surviving spouse into splitting the estate upon first death into an A and a B trust. The B trust is irrevocable. You cannot spend the money. You can only get the income out of it. So it does do a great burden to the surviving spouse unless there is the type of wealth that this trust is actually designed for. And I'll be honest with you, if we get involved with advanced estate planning, by the time we talk about the other types of trusts that will be needed or could be used, you don't want the AB trust anyway. So with that in mind, this is a disclaimer trust. This is a good trust if you have an option on first death to do an A or a B split. That's still good, and it doesn't lock you into a given situation. The AB trust, however, does lock you in. You are forced to do what it says, so that's why I want you out of it. So with that, we're going to get into closing up the estate plan conversation at this particular point in time. What I do want to mention is every year we do have a new gift tax rule usually. Right now, it's currently at $15,000. What I mean by that is you can give away $15,000 per year to anybody you want, and nobody cares that they're getting it, or you're actually giving it away. Now, there's two gift tax rules, which is why I really brought this up at this particular point in time. And it really boils down to a lifetime gift tax exemption that you have, plus the annual gift tax exemption. The annual gift tax exemption is what I'm showing you up here on the slide, $15,000 per year per person. But the lifetime gift tax exemption is equal to the estate tax exemption that we just talked about. And you can literally give away $11.7 million over your lifetime without ever paying a gift tax. I mention this because when we get around to doing a presentation on Medi-Cal planning, which is for long-term care, we're going to be talking a lot about how to save your house, your pension, retirement plans, all the money you have accumulated in the bank and in your investments, because California allows us to save everything that you have and get on the public benefit. And when we do that savings, we're going to be using the lifetime gift tax exemption so that nobody in the long-term care planning has to pay a gift tax. All right, with that, what we're going to do is kind of wrap up. I'm going to wrap up with the other documents that actually go with the trust. And in particular, what I'm getting at is you're going to get an advanced healthcare directive. This is your healthcare power of attorney, and it includes the living will. A lot of people are confused what a living will is. A living will is really the documentation or the language that pulls the plug. In other words, you know, I don't want to be supported on life support, so pull the plug. That's what a living will is all about. In the old days, prior to 1992, a living will was a separate document from your healthcare power of attorney. But after 1992, both the living will and the healthcare power of attorney have been put into one document, which is why we now call it an advanced healthcare directive. Now, advanced healthcare directives are, well, they're not very changeable, meaning that there's not a lot of changes that happen to these documents. But the number 4 bullet point down there, the HIPAA compliance, you want to make sure your advanced healthcare directives have the HIPAA compliance. HIPAA is the federal law regarding the privacy of your medical records, and you have to have a little paragraph in every advanced healthcare directive with this clause in there so that the hospitals and the doctors that you're working with and the nurses feel comfortable in talking to your agent about your condition. Because if they're not HIPAA compliant, they may refuse to talk to your family and specifically the agent that you've nominated to hear and make decisions for you if you can't, and we don't want that to happen. So you need that HIPAA language in these documents. The next document you're going to get is probably the most important document that you could have outside of the trust itself. It's your financial power of attorney. Now, banks are very picky about honoring these financial power of attorneys. They're very skeptical of them. My biggest advice I can give you is if you're starting to take care of mom and dad and you're needing to, use the financial power of attorney to manage some of their assets, I would go into the banks that your mom and dad frequent, get to know the people, have them recognize you, because when you really need to go in and need their help to manage monies, it's going to help if they recognize who you are and the fact that you are a son or a daughter that is walking in to manage things on behalf of the folks. Typically, if you're a guy, you're a son, you're walking in there at 3 o'clock on a Friday afternoon at Chase and you're, saying, I got to get into my mom's account, I got to pay a bill, they're not going to let you do it. So, get to know who these people are. It goes a long ways. Yes, the financial power of attorney document has all the legalese giving you the right to manage things on behalf of your parents. Now, one of the most important part is our elder law part of our financial power of attorneys. That's the Medi-Cal language I'm mentioning down there. We're going to do another presentation at some point regarding Medi-Cal. What I want to mention right now is California is the only state in the nation that allows you to shelter all your assets, your pension, retirement plans, your money in the bank, and your real estate prior to qualifying for Medi-Cal to pay for long-term care. We're running under 1980 federal Medicaid rules that allows us to do this, and we're the only state left in the nation that does allow us to shelter everything we have. If you go to any other state to deal with long-term care, there is no movement of any of your monies, real estate, or pension retirement plans 5 years prior to going into the nursing home. Otherwise, you're ineligible. So in other words, you really can't do it in another state without a lot of hassles, or I should say spend down the money unnecessarily. Again, in California, we can save it. It starts with the language, which is why I've been emphasizing this. And so our Medi-Cal language appears both in our financial power of attorneys, but it also appears in the trust. So if you're a person that's getting only a will, you will get the financial power of attorney with that will, along with the healthcare power of attorney, and you will also have the Medi-Cal language just in case long-term care becomes a big issue. Now, you're also going to get a nomination of conservatorship. The purpose for having a healthcare power of attorney and a financial power of attorney is not to have to go into court and set up a conservatorship. However, sometimes things go south on us, right? And sometimes it's usually because our parents will not let us take care of themselves. They don't recognize that they need the help. If this becomes a problem in your family and you now have a situation where mom and dad are actually really hurting themselves by not allowing you to help them, you may need to go in and get a conservatorship because they're not letting you operate under the healthcare or the financial power of attorney. So the way we cut through the bureaucracy of going into court on this matter is we put a clause in your healthcare power of attorney and in your financial power of attorney where you're already nominating who your conservator is going to be. When I file paperwork in court regarding a conservatorship, that paperwork asked to attach your healthcare and your financial power of attorney. The reason for that is the judge is going to look at this clause and determine who you picked when you were competent, and that has a lot of weight on who the judge is going to approve as the conservator of yourself and your estate. So this is a very important clause, and that's why I emphasized it today on our presentation. Now, you're also going to get what we call a letter of instruction. You know, the trust lays out who's going to get what and how much, but it a lot of times operates in percentages, but it doesn't really go into who's going to get the clock, who's going to get the car in the garage, who's going to get that picture on the wall, so to speak. Well, this is what the letter of instruction does. The letter of instruction is attached to your trust, and in your own handwriting at your own kitchen table, you can write down who's going to get personal effects. And you're allowed to scratch it out and change it. All you have to do is sign and date it. It's in your handwriting. It's a part of the trust, and therefore you can make personal choices on who gets personal items. Now, a lot of times, if I can stereotype how this works, us guys don't really care one way or another, and ladies love to fill it out. So my bottom line here is this is a great tool to use. You can do it yourself at your own kitchen table, at your own leisure. It will be part of your estate plan, and yet you're not coming back to me to amend a trust on who's going to get a clock. That would be kind of silly, right? So this is where you do that. Now, this letter of instruction goes beyond that. You can write down burial instructions and who should be notified if anything happens to you. You know, if you're going to have a safe at home, you want to know how to get into it, this is where you put that information down too. Finally, you're going to get a pour-over will with your trust. Everybody asks me, why do I have to have a will with the trust? Well, remember, the trust is only as good as what we're actually titling into it. By changing your house title from joint tenancy to the living trust means we're avoiding the probate. But remember, there were certain items we're not putting under the name of the trust. Your checking account, your cars, and your personal stuff. So the pour-over will is designed to grab those leftover items and pour them into the trust as if they were part of it. So if you think about it, the pour-over will acts as a catch basin. It grabs the leftover items we're not titling into the trust and pours them into the trust, and unless you pick a beneficiary. So for example, IRAs, life insurances, your pension retirement plans, and annuities, they're not going to go into the trust through a pour-over will because you already have designated beneficiaries. They go directly to those designated beneficiaries. So lastly, if you're husband and wife, I'm going to give you a community property agreement, mostly just because we're in a community property state. Now, I purposely dummied the language down on this. I don't get into what is separate property, what's community property. I found that lawyers like to take that type of documentation and spin it into something that it's really not. And so if the language isn't in there, they can't take the language and spin it into something that it's not. So what I'm getting at is this community property agreement really only deals with collectible type items, you know, like, I don't know, the baseball card collection, the Yadro collection. You don't have a title to those types of assets, but we're going to call it a community asset. And in doing so, it allows a stepped up tax basis to occur on that collectible item at death, which means the family can sell it without a capital gain hit. So most people don't have a use for the community property agreement, but it is a necessary document that goes with the package itself. So with that, that's kind of our presentation today. Really appreciate you for showing up. Again, we offer a free consultation. If you've got a trust, bring it in. I'll be happy to review it. If you got long-term care questions, I'll be happy to go over that. If you have questions on how to wrap up a trust, we can go into how to wrap up a trust and the process that it takes to do so. If you want to get started with a living trust, of course, that's what we're here for, and I'll be happy to go over all of that. So with that, our contact information is on the presentation I believe you're seeing. And so all you have to do is just give us a call. We'll set up a free consultation, and I'll go over any issues that you might have. All right. Thank you very much. Appreciate it. Dale Bethel, Bethel Law Corporation.